My name is Brian Jordy. I'm a lawyer at Domina Law Group in Omaha, Nebraska. My partner Dave Domina and I represent 3 landowners who challenged the proposed Keystone XL pipeline route that crosses through Nebraska. We filed a case on their behalf on May 23, 2012. Our efforts have been focused primarily on landowner rights and defending the Constitution. The critical question we put before the court was whether or not it's constitutional to give the governor of our state the unilateral power to grant eminent domain rights to a foreign corporation. On Friday, January 9, 2015, the Supreme Court, some 32 months after we initially filed our case, issued a 64-page opinion. It's perplexing, confusing, and unclear on first glance what it really means. So here's what happened. The first question is a question of standing, which is a legal term essentially meaning, can you as the plaintiff, our 3 landowner clients, even appear in the court and ask for relief? On the issue of standing, of whether or not our clients could move forward, 4 of the Supreme Court judges said yes, and 3 said no. So we won that issue 4-3. The next and critical question is the one of constitutionality, the one about the governor having the sole power to give eminent domain rights to foreign corporations, such as TransCanada and its Keystone XL pipeline. On that question, perplexingly and historically significant, 3 of the 7 judges refused to participate, refused to make any decision at all, leaving 4 to vote unanimously in our favor that yes, we and our landowner clients are correct. This law is, in fact, unconstitutional. But because this is a question of constitutionality, Nebraska is a state where it requires 5 affirmative votes in favor of the landowner's position to declare victory. Because 3 of the 7 judges sat the decision out and failed to say yes or no, it was impossible to get those 5 votes.
Since last Friday, I've seen hundreds, maybe thousands of news stories saying that a hurdle to TransCanada's construction was removed. Any thoughtful reading of the Supreme Court's opinion clearly discloses that's not the case. Nebraska landowners have not had a 5th judge, as is required by our state constitution, vote on the validity of Nebraska's statute. What we do know is that every Nebraska judge who has cast a judicial vote on that question has been with the property owners.
As Dave mentioned, the only 5 judges in the entire world that have ever looked at this question of constitutionality that we raise have voted yes in our favor. First, in February 2014, Judge Stephanie Stacy in Lancaster County District Court, Nebraska, voted yes in favor of our position and our landowner clients. Now, recently, a few days ago, the Supreme Court, the 4 that participated, all voted yes for our position. So again, the only 5 individuals to ever cast a vote have voted in our favor. So what this effectively means is that because 3 of the 7 failed to participate, a supermajority either way on this question was impossible, meaning this decision has simply been pushed down the road or punted away to be answered on another day in the future. It's also important to keep Nebraska and the issue that needs to be resolved here in perspective. What happens in Nebraska is wholly separate from anything on a national level. What the president does or doesn't do and what votes Congress does or doesn't take are completely irrelevant to our specific state law questions that remain unanswered. And until they're answered, the question is open and unresolved in the state of Nebraska.
Now, folks, TransCanada has to decide. Does it proceed under a statute that is almost certainly unconstitutional? Or does it go to our Public Service Commission and honor our Constitution? I don't know which TransCanada will do, but if it chooses the route that we think is unconstitutional, the property owners of this state and we as their lawyers are prepared to meet TransCanada.
Unfortunately, the cloud of uncertainty that we had hoped our lawsuit would answer once and for all is alive more than ever and looming larger over TransCanada's head than before. It's up to TransCanada to make the next move, to play the next card, and they don't have many cards to play.
Let me tell you what the real disappointment in Nebraska government is about TransCanada. We have a foreign company engaged in the for-profit business of transporting a very complex environmental product. It wants to push that product underground across our state. It chooses to do that with an easement document that would permit TransCanada to abandon the pipeline in the ground beneath Nebraska's soil when it decides not to use it anymore. Now, why should we in Nebraska have to clean up after some foreign company's for-profit run comes to an end across our state? TransCanada should clean up its own mess. And if along the way, while it's using that pipeline, it makes a mess, TransCanada should bear the liability, not the people of Nebraska. You know, the Nebraska legislature can fix those two things with a simple law that makes those two problems go away. How disappointing it is to me that the legislature of this state hasn't stood up for the landowners of this state to protect them. Until our legislature fixes those flaws in TransCanada's easements and does so in a constitutional process, the landowners here aren't finished fighting, and neither are we.